Can a person be charged with DUI if they refuse the blood or breath test? In Indiana, absolutely. If a person is offered a chemical test, blood or breath, by an officer because the officer believes they've operated the vehicle while intoxicated, then if that person refuses the breath test, it does not mean they're not going to get charged with a DUI. All that means is the officer, at least in Indiana, is going to call the judge and get a warrant for blood. And that's going to create all sorts of problems for the person who has refused the blood or breath test. Number one, they're still going to get the blood. Almost every county in Indiana, at least the ones that I practice in central Indiana, are able to get warrants for blood pretty quickly. A warrant for blood is very fast. It's email. Lots of bigger counties, including Marion County, have on-call judges all night, even on Christmas. It's crazy, isn't it? And they're just signing stuff. Now, there has to be a probable cause for the warrant, but it's a very low burden for the police to get a warrant. And then if they get the warrant, they're authorized to get that blood from you. And most people aren't going to fight with the police, but God forbid someone starts fighting with the police or the nursing staff or the people that are drawing the blood. That can easily result in felony resisting law enforcement charges. And then in some counties, including Boone County, Indiana, they'll file a contempt of court against you because that signed search warrant, well, that's an order from the judge. It creates all sorts of problems, and typically the officers will still get your blood. But then DUI is the gift that keeps on giving. If a person refuses the blood or breath test, then that person is going to lose their license for minimum 1 year, 2 years if they have a prior DUI. Now, those are what's called refusal suspensions. Now, a refusal suspension in Indiana is not eligible for a work license, which is really a specialized driving privileges. By statute, they're excluded, can't get them. So a person who refuses the blood or breath test, they typically still have a DUI, and now there's almost no way to get them driving legally while the DUI case is pending. There are some extreme exceptions that probably don't apply to you. But refusals are very tough and they're hard. And why does Indiana come at refusals so hard? Well, it goes back to something called implied consent. When a person gets their driver's license in Indiana, they sign on the dotted line that they will agree to do a chemical test if requested by an officer as part of getting their driver's license. And so that's a rule. And if you violate the implied consent, that's where the refusals come in, and that's where these harsh driver's license penalties come from. So a person is in no way, shape, or form safe from a DUI if they refuse to blow into the breathalyzer. In fact, you've made it probably much more complicated for your driver's license. But that's okay. I'm a positive person. Look at this smile. If a person has refused the chemical test and they're facing a DUI with the refusal, give me a call, 317-632-3642. I can talk that person through some options, and not all hope is lost, of course. A judge does have the ability to terminate the refusal. In some extreme cases, a prosecutor might agree to terminate the refusal. And then if nobody will agree to terminate, there can always be an argument that terminating the refusal is in the best interest of society. Again, Marc Lopez. If you have any questions about DUI defense in Indiana, give me a call. I will talk about DUI defense all day. I love it. It's a passion of mine. Most importantly, though, remember to always plead the fifth.